Welcome. My name is Ben Wright. I am an instructor at the SANS Institute, and I'm also a lawyer in Texas. At SANS, I teach the course titled The Law of Data Security and Investigations. And you can get a copy of these slides at the registration page for this webinar. So you can download that while we're talking, or and write notes if you want to, or you can download it later. Another thing I'm going to mention is that in the chat window, you should have access to a URL that will send you to the evaluation. And if you know SANS, you know that we love evaluations. So we would like to hear what you have to say when this is over. So tonight we're talking about the arrest and criminal indictment of 2 employees of Coalfire. These employees were doing penetration testing work. And I know, having talked about this topic before in public, this is a very sensitive topic within the cybersecurity community. And I know people have some strong opinions about this. And I respect all of the strong opinions that I've heard about this topic. And so I want to try to set up what I'm doing here. I'm not taking sides one way or another, and I'm going to try to avoid criticizing either these 2 employees who were indicted or the law enforcement officials in Iowa. I'm not going to advocate a position about whether this should have happened or should not have happened. What I will criticize is some of their legal documents, but that's a very technical legal type of thing that we'll get into here in a few minutes, and that goes more to the people writing documents rather than to these 2 particular penetration testers or to the law enforcement officials in Iowa. And so I guess I'm not passing judgment on anyone, though yes, I am going to say some documents weren't well written, and I'm going to explain why I think they were not well written. And my purpose really here is to help educate the community and anybody who's interested. And those people who are interested include not just the cybersecurity community. I gave this presentation in Adel, Iowa in October, and Adel, Iowa is where this incident occurred, and some members of the local community showed up, and they had some opinions that were very different from what you would hear in a typical cybersecurity community presentation or a SANS type of presentation. So this is a controversial topic, and I'm humble about it, and I admit I do not know all of the facts. There are some facts that are not in the public, and probably will never get into the public, or may not ever get in the public. And I've got to admit, so that as I'm evaluating what happened here, that I don't know everything that might be relevant. You can leave questions. There's a question window where you can leave questions as we go along. I like questions as we go along, so you don't have to save your questions until the end. Although if the questions start to become kind of long and hard for me to read in this format, then I'll just move on with my material and then come back to the questions at the end. I believe that there are a number of lessons that come from this situation. And those lessons, I believe, apply beyond just penetration testing. So what happened here is that an enterprise client hired some contractors to do some work that other people might look at and consider to be a little suspicious looking. Penetration testing is often suspicious looking work. There were some miscommunications. There were documents that weren't well written. And ultimately, the corporate or enterprise client and the contractors both suffered. And I argue that this basic little experience is something that we can see in many different parts of cybersecurity, not just in penetration testing. And so it could apply in a lot of digital forensics incident response type of context. And so I argue the lessons that we're going to learn here from this case can be useful to us far beyond just penetration testing. So here's the basic plot. The state court administration of Iowa has the authority to do some things about state courts, manage state courts. Some of these state courts are actually housed in county courthouses, like this beautiful Dallas County Courthouse that we see here. This is Dallas County, Iowa. And so the state court administration wanted to evaluate security all across its state courts, including its state courts that are physically located in these county courts. And so the court administration hires Coalfire, which is a cybersecurity company, to do some penetration testing. And broadly speaking, this penetration testing included physical entry into county courthouses. And so 2 employees of Coalfire, 2 penetration testers, break into the Dallas County, Iowa courthouse at midnight. And the sheriff shows up, and the sheriff's deputies show up, and the sheriff is not happy. And so the sheriff arrests these guys, keeps them overnight, and incarcerates them in jail overnight, and commences to press criminal charges against them the next day. And the local county prosecutor gets involved, the county attorney, and he advances these indictments, and he will not drop the criminal charges. Now, the criminal charges started out pretty serious as felony, including burglary or possession of burglary tools. And a felony is a serious crime, and you can go to jail for quite some time for committing a felony. Now, as this went on, it got a lot of attention, and the prosecutor was paying a lot of attention to it, and the prosecutor did lower the charges from a burglary type charge to a criminal trespass charge, which is just a misdemeanor, and a misdemeanor is a little bit like a traffic ticket. Nevertheless, for some time, the prosecutor would not completely withdraw the criminal complaint against these 2 employees of Coalfire. And this created quite a stir within the penetration testing community. A lot of penetration testers said, my goodness, you know, I do stuff like this. And we in the community have never had an experience where criminal charges were pressed and were continued to be advanced against true penetration testers who had been hired truly by an authoritative client. A very helpful document to understand this case is this Coalfire investigation report dated October 9, 2019, written by this law firm for Gray, Baker, Daniels. The Supreme Court of Iowa oversees the state court administration. So as this controversy unfolded, the Supreme Court, and in particular the Chief Justice of the Supreme Court, got very involved in this situation. And so the Supreme Court hired this outside law firm to run a full investigation of what happened. And so the law firm gathers a whole lot of evidence and reads a lot of documents and interviews a number of people and comes up with a number of useful recommendations on how to avoid this kind of thing in the future. And so if you're interested in this topic, I highly recommend the report. However, an aspect of that report is that the County of Dallas, where the prosecutor was pressing his charges and the sheriff worked, did not participate. And so Dallas County basically was saying, okay, courts, you run your investigation, you can have your own opinion, but we've got our opinion, and our opinion is that these guys committed a crime and they should not have been breaking into that courthouse at night. So even though this report came out, the sheriff, as we'll see here in a few minutes, said, well, I haven't read that report, and we're still pressing charges against these two guys from Coalfire. We think that they have done something wrong. And one of the things that is apparent from the report is that there were a lot of documents signed between Coalfire and the client, the state court administration. And there was a lot of exchange of documents, and there was a contract, and there was a get out of jail free card that we're going to talk about here in a few minutes. And there were other documents describing the scope of work and so on. And one of the things that is apparent from the report is that these documents were not well written. They were not consistent. And as a lawyer who has some experience helping all kinds of businesses write documents and manage documents when they do multiple projects over time, I know that it can be really hard for a business to be consistent with its documents all the time. It's expensive to have a lawyer involved to draft every contract and every statement of work and make sure everything all fits a particular engagement. And so my sense of it was that neither Coalfire nor the state court administration had a lawyer working really intensively on these documents to try to make sure that they made sense and that they were consistent with one another. And so this inconsistency leads to part of the problems with the sheriff when the sheriff shows up at midnight and finds these two Coalfire penetration testers in the courtroom. And the sheriff ends up getting contradictory information. The sheriff starts looking at documents, and he starts talking to some state court administrators, as I'll explain here in a few minutes. And there's inconsistency about what are these guys supposed to do? What are they authorized to do? Did they operate within the scope of their contract? Did they exceed the scope of their contract? And this inconsistency contributed to the sheriff's position there at night. You guys are wrong, and you shouldn't have done this, and I need to arrest you. And this inconsistency probably contributed to the prosecutor continuing to press charges over time. Now, does that mean that the Coalfire employees actually committed a crime? I don't know the answer to that. And I think it was an interesting question as all this was unfolding over a period of months. Did the Coalfire employees actually commit a crime? And I'll get in a moment into a little more detailed definition of what would need to be proven in order to show that the Coalfire employees had committed a crime. And questions that started to arise in my mind as I was studying all these documents and gathering all the information about the case was, if it was a crime that these guys did it, was it really the employees that committed the crime, or was it the company that committed the crime? Was it the one that really was at fault here for putting its employees into a situation and guiding them into a situation where they just felt like they were doing what they were told to do, but ultimately it was really the company that was guiding them and supervising them. And thus, further, if there was an argument that instead of criminal trespass, that it was civil trespass, again, the question I thought was unanswered was maybe the company Coalfire was the one that had civilly trespassed onto the property of the courthouse. But then yet another question that came to my mind as I was studying the documents and thinking about the peril that these Coalfire employees faced is whether it really was the state court administration that was at fault. And a question that arose legally as this a case was playing out in the public was, what authority does the state court administration have to physically test the security of the courthouse? The courthouse is owned by and managed by the county, whereas state court administration is a state agency, and yes, it manages the state court that happens to be on one floor in the county courthouse. But did the state court administration actually have the authority to try to break into the courthouse itself and break in the front door and the back door and the side door and that type of thing? And that was a question that was never thoroughly answered, in my opinion. The report from the law firm did talk about that question, and it showed some legal authority suggesting that the state court administration did have the authority to do whatever is necessary to provide physical security of its court that happens to be in the courthouse. But that was just rather preliminary arguments by that law firm. And so I think that there still was a question about whether the state court administration did what it was supposed to do, whether it was at fault. And ultimately, what we're going to learn here in a few minutes is that the Chief Justice of the Supreme Court said, we made a mistake. He admitted in public, especially at a legislative committee hearing, that we made a mistake. So, and so then one of the questions that's going through my mind as I was thinking about the state court administration and this Chief Justice admitting that state court administration had made a mistake. Well, if they made a mistake, then why are these two individuals having criminal charges pressed against them as individuals? And so the prosecutor maintained for a number of months that, in fact, a crime had taken place, and in the claim that the prosecutor was advancing was that there was some kind of criminal trespass under this Iowa Code 716.7, which means entering property without permission and some kind of bad intent. So the prosecutor would have had to have proven beyond a reasonable doubt that these two employees had violated that section of Iowa Criminal Code, that they had entered property, meaning the courthouse, without permission, and they had some kind of bad intent. And so their intent was relevant. And there were pieces of evidence in this case suggesting that these employees actually had good intent. And that included the fact that they did have a contract with a state agency. There had been general discussions about trying to probe into county courthouses after hours. Now, there was not a lot of clarity about exactly how that was supposed to take place. Furthermore, these employees had been at work doing their penetration testing work before they got to Dallas County. So the night before they broke into Dallas County, they broke into a state administration building in the capital of Des Moines. And so they actually got to the desk of one of the state court administrators who had hired them, who had been working with them and had reviewed the contracts. They got to the desk basically of their client, and they got into the building at night. They worked their way through the state court administration building. They make it to the desk of this administrator, and they left their business card on his desk as a calling card. And so next day he comes into the office and he sees, hey, these Coalfire guys got into my building. They got all the way to my desk. And so he sent them an email congratulating them on their good work. Okay, so the fact that they've been breaking in and then they get congratulated by their client suggests, hey, we're doing what you want us to do. You hired us to do this. So we're not evil people. We don't have malicious intent. Okay, so I see some questions coming in here, and I'm going to start looking at some of them, and then I may run out of time on questions and save them to the end. So the first question says, does the contract itself equal permission to enter? Where was Coalfire's management in this process? Well, okay, that contract, whether it's permission to enter, is part of all the controversy here. Because on the one hand, the state court administration says, well, we need to test this site where our court is. And so we have a contract and we're telling you to do this. And we think you're supposed to do this. On the other hand, the sheriff says at midnight, the sheriff says, wait a minute, those state court administrators don't have the authority to give you permission to break into my courthouse because the courthouse is owned by the county. So the answer is it was confusing. That was this whole thing was very confusing. And my real lesson here is that many of us in penetration testing and cybersecurity, we do suspicious looking things. And therefore we can do something that somebody else thinks is wrong. Therefore, we are wise to be asking these kinds of questions before we break into the courthouse, rather than waiting till midnight and then putting the sheriff on the spot at midnight to make this judgment call about whether these guys had permission. Okay, so then the next question I see here, and I'll see if I can get through this and without spending too much. This is not working. Okay, it says, does the fallout from this incident demonstrate a need to have a local official, in this case, the Iowa County, to act as a middleman between the testers and the Iowa County Court and the Sheriff's Office? Going forward, should all penetration testers involve local contact as part of the test? The answer to that is very possibly yes. Now, when I gave my presentation in Adel, Iowa, interestingly, the sheriff himself showed up. And a lot of the people who had come to this presentation, it was a larger conference, it wasn't just about me, but there's a larger conference, and a lot of the people who came to come and participate in this conference were state employees of the state of Iowa, because Adel, Iowa is close to Des Moines, so it didn't take these administrators from the state of Iowa very much time to drive over there and participate. So these administrators and these not just administrators, they were just employees of the state of Iowa, and they worked for all kinds of agencies, not just the state courts. They were very interested in this because they were basically, they said, look, you know, I run some other agency like environmental protection or something there in Iowa, and I might hire people like this to do this, and I want to figure out what do I need to do so that my people don't get into this kind of a mess. And so I remember one guy asking the sheriff if he would have properly participated if someone from state courts had called him and said, these guys are going to do this, but we want to coordinate with you, the sheriff. So you, the top dog in the law enforcement, you know about it, but you're not going to tell your deputies about it. And so we'll see how the deputies react to the situation. So that's what the sheriff said, yes, I would participate. And the sheriff said, you should have called me. And the larger lesson here is that penetration testers and others doing suspicious kind of work need to think really practically. Who is going to be unhappy, and how do I manage that unhappiness? For example, should we insist that our client call the sheriff or someone like that and work out a deal with them so that we can run a proper test, but the sheriff doesn't get hot at midnight. So yeah, I think the answer basically is yes, you should figure out some kind of a way to think this through and think through how do we manage the emotions of what's going to take place and the politics. And there was a lot of politics here. And interestingly, when I gave my presentation there in Adele, there was a local citizen who came and said some things during my presentation where it made it really clear that she had a political point of view, and her political point of view is that the sheriff did the right thing. The sheriff is our local good guy, and those dudes came in here and broke into our courthouse. So there was a lot of emotions and politics around this, and penetration testers are wise to be thinking about these things. So now, from the point of view of these Coalfire employees, they might have felt a little bit like pawns, because you have this political battle between the state court administrators and the sheriff and the county, but the little guys, they're the ones who end up having the charges pressed against them, and they're the ones who have their mugshot spread all over the place. And so all that publicity is not good for the Coalfire employees. The prosecutor needed to take all of these topics into consideration. He had an ethical duty to take these topics into ethical consideration as he was pressing these charges. And ultimately, I'm going to give a spoiler alert. We're going to learn that the prosecutor withdrew the charges. It took a little while for him to get there, but I think that ethically he concluded that it was the right thing to do to withdraw these charges. There was a very interesting article published in November that shed light on this situation. And ARS Technica interviewed the sheriff to find out what he had to say, and they also, interviewed the county prosecutor. And the sheriff essentially said, those guys that I arrested that night from the courthouse, from Coalfire, they were nice guys. They were not disrespectful, and I know that this conviction would leave a real negative mark on their records. And he said, if they were supposed to be here that night, then I think the charges should be dropped. Now, the sheriff is just saying this in public, and the sheriff is not the one at this point who advances the prosecution, because it's now in the hands of the prosecutor. And the prosecutor said to ARS Technica that there's still some evidence that has not come out. And so the prosecutor was saying, I've got some additional evidence, even though there's been a lot of reports about this case, and there's been a lot of people talking about this case, like the sheriff and like the defense lawyer working for the Coalfire employees. The prosecutor said there's still some piece of evidence that I'm not going to bring out right now, and that is relevant to this overall prosecution. So at that time, I was trying to figure out why the prosecutor was continuing to push this thing. And my guess, and it was just speculation at that time, is that there was some kind of negative evidence against the Coalfire people to suggest that they really had some negative intent. And I couldn't figure out what it was, but I could speculate something like this. The Coalfire employees break in at midnight, but we don't know where they were at about 3 o'clock, 2 o'clock in the afternoon. Maybe they had come poking around the courthouse in the afternoon. Maybe they encountered someone who said, you guys are not supposed to be here, don't come back, get out of here. And so if they encountered someone like that, then that's a piece of evidence that they were warned to leave, and then they came back at midnight. So maybe there was a piece of evidence like that the prosecutor had, and he was holding that back, and he felt ethically he couldn't reveal that evidence in the public. Therefore, he had to hold it back for trial. So I don't know what that mystery evidence was, because as I'll say here in a few minutes, that the charges were finally dropped in January. But one of the things that I felt strongly at the time that I gave this presentation in Adele was that there was a lot of anger being expressed out in social media and other ways from essentially the cybersecurity community toward those two public officials in Dallas County, Iowa, the sheriff and the prosecutor. And then it was so interesting for me to actually be on the ground there and give a presentation and have a citizen who lives there in that little town come in there and stand up for her local politicians and her local leaders. And I felt personally that there was some disrespect coming out of Twitter that I was seeing, and other social media from the cybersecurity community. And so I felt like that I didn't want to get at that time too much into sermonizing, but I felt like people in the cybersecurity community needed to calm down and treat these county officials with respect, because they were doing what they felt was right, and actually they had local political support for what they were doing. And furthermore, some people felt that the prosecutor needed to reveal this negative mystery evidence that he had. On the other hand, ethically, he's not allowed to do that. He's very restrained ethically as to what information he reveals at what time. And basically, he shouldn't be trying his case out on Twitter or on the television news. And because if he does say, well, here's all this sensitive evidence, then it may prevent the defendants from getting a fair trial. It may taint the jury pool. So if jurors are going to be called to come and hear the case, and the jurors already have been reading Twitter and all the evidence that the prosecutor has, then they may not be neutral when they're called in to serve as jurors. So the prosecutor had a good reason not to tell his whole case, and apparently he believed that the evidence did support a criminal conviction. At least he did up until January. And so a general comment that I have for the cybersecurity community is many of us do work that has legal implications, and the legal process can be slow. And I could sense from a lot of cybersecurity people and penetration testing people there back in October, they were saying, we need to get to the bottom of this and resolve this right now. You, the prosecutor, you need to come out and explain why you're pressing charges against these people, instead of saying we're going to wait till April for a trial. On the other hand, I say that cybersecurity professionals need to respect the process that it needs to be followed through the legal system. And so we should not have been demanding all the evidence come out in an informal way or haphazard kind of way. And I believe that some members of the community could have shown some more respect for the law enforcement authorities at that time. Okay, we get into January, and the prosecutor does withdraw the charges against the employees, and I don't know why. And my guess is that as the prosecutor was evaluating the case and negotiating with the lawyers for the two penetration testers, he felt that the case wasn't that strong and maybe there were some other little pieces of evidence that came out that weakened the case in his mind. Nevertheless, he withdraws the charges in January. Here is an important point, though, that I think we all need to bear in mind, and that is this whole experience was an utter disaster for the client, for the Iowa State Court administrators and the State Court administration that hired Coalfire. This was not the outcome that they wanted. Sure, they wanted the charges dropped, but they didn't want this whole circus from the very beginning. They didn't want those guys arrested. So the engagement of the penetration testers was just a complete disaster for the client. And so I'm suggesting that some of the lessons that we can draw from this case can help to prevent clients from having disasters, and of course also help prevent professionals like the penetration testers from ending up on the wrong side of the law, or ending up on the wrong side of a jail cell at 2 o'clock in the morning. So to drill a little bit more deeply into the mistakes that were made in the legal documentation, I noted that the Chief Justice of the Supreme Court was called in front of a hearing to the state legislature, and he says, okay, you know, he says, I personally wasn't involved in this situation, but I take responsibility for it because I'm basically like the CEO of this enterprise, state court administration. And he said, I'm sorry, we've made mistakes. And so it's clear from the review by the law firm that the documents were confusing. The documents were not a good guide for telling exactly to Coalfire or to the sheriff what the Coalfire employees were authorized to do and what they were not authorized to do. So there was confusion about whether the documents authorized going to a county building at night. So the state court administrators who were running this didn't think this thing through as deeply as they should have. They signed these documents. They didn't really read them really carefully. And I'm saying the state court administrators didn't think it through. I think that Coalfire as a corporation didn't think it through real carefully either. And so the documents say some things about doing things in the evening, and then the Coalfire employees break into the state building at night. And so the next day, the state court administrator comes into his office and he sees that little card. What he didn't think about was, these guys are operating at night. I wonder what the implications are if these guys go break into a county courthouse at night. You know, them breaking into my building at night is one thing because I run my building and own my building. But then, you know, what's the sheriff going to think out there in Dallas County? Well, that little connection was not being made, I think, in the minds of the state court administrators. And one of the comments and suggestions that came out of the report written by the law firm is that in the future, when this kind of thing is negotiated, then some other people with legal and political experience need to get involved, because there are legal concerns and there's also political concerns. And my sense was that these state court administrators, who were actually the ones contracting for the work, were technical people rather than people who have a lot of experience with politics. Somebody left a comment that says that would be speculation. Okay, and yes, I think if you're referring to my thoughts about what kind of evidence the prosecutor had, that was the mystery evidence, yes, it's speculation. I absolutely admit. I don't know what else you're referring to as my speculation, but when I speculated that the Coalfire employees met someone at 3 o'clock in the afternoon, that's just speculation. So now somebody says, in terms of legal documentation, do you think Coalfire used boilerplate contracts? Yes. I really got the sense that Coalfire had some boilerplate contracts they've used over and over again, and they're just taking their forms and giving them to a client. And there was some customization of the form, but I sensed that there was a lot of just boilerplate language that they used over and over again. And this person says, I've used them before, and this incident freaked me out in terms of liability. Okay, so then the next person says, shouldn't we add lack of planning experience in the whole fiasco on the part of the court officials? Yes, I believe that the court officials did not do a good job. And I believe that in effect, the report from the law firm said the same thing and said, these guys are technical people, and you need to get people with political and legal experience looking at this and thinking this thing through, rather than people who just who do technical work. And so I see there's another comment. All scenarios should have been considered prior to putting together the documents. I agree with that. Okay, but I've got a point here at the bottom of my slide. You know, you're running a business like Coalfire, and you've got dozens, hundreds of clients. I don't know how many clients they have, but they run a lot of transactions. And so they get these form documents, and it is expensive to customize the form perfectly for each engagement. It's also a lot of expense and red tape for the state court administration to go get a lawyer and go get someone with political experience to come in and review these documents and think through all the scenarios. It just slows things down a lot. Okay, so someone says, my opinion, wrong. Okay, wrong. Okay, it is Coalfire's responsibility as the experts. Fine. Okay, as the court, not sure I would be able to know all the situation, hence we hire expert. Okay, fine. You can have your opinion. That's okay. Okay, so from the county's perspective, the county felt that it was being taken advantage of by being tricked. You know, here at midnight, having the sheriff and his deputies racing to the courthouse because the Coalfire employees had broken in. They intentionally tripped the alarm because they were actually testing to see how long it would take for anyone from the sheriff's office to show up. So they were timing. Say, okay, I got in, and now my timer's on. I'm going to see how long it takes for law enforcement to show up. From the point of view of the sheriff who came and talked at our little conference, he says, wait a minute, we are a rural county, and I got these deputy sheriffs at midnight spread all over the place, and then suddenly there's an alarm in the town, and so then they've got to race in the dark to this place just so that they can be tested to see how long it takes them to get there. And he says, that's dangerous. You know, I can have a wreck out. My people can have a wreck out there when they're racing through my rural roads. And so the sheriff was saying, we were taken advantage of. We weren't consulted on this. And interestingly, when the legislators held a hearing on this, the legislators stood up for the local county, because essentially the state employees are just employees of the state, and the legislators are not going to stand up for the state administrator employees. They're going to stand up for the local politicians and say the local politicians deserve more respect, in effect. So generic lessons. It's easy for me to say, a lot harder to articulate this in a particular situation, everybody needs to exercise good judgment, and that includes the client and the contractor, like a Coalfire, and the actual employees on the ground. And you know, from the point of view of the employees on the ground, a question I had, that is the two Coalfire employees, a question I had is what kinds of guidance were actually given to them on what they should do, precisely what steps should they take to break into a facility. The documentation did not give them a lot of guidance on what they were doing. My guess is they had experience working for Coalfire and doing things like this, but I question the degree of good supervision that they were getting in light of the political environment that they were getting themselves into. And so I can easily kind of point my finger to a lot of different parties, like management at Coalfire, as well as the state court administrators, saying you need to be thinking these things through and make sure your people have the appropriate guidelines as to what to do as they get into this environment and some other kind of environment. So these broad general lessons, these generic lessons, I believe apply to all kinds of things we do in cybersecurity, like DFIR, not just penetration testing. So one aspect of good judgment means good communication, and good communication includes Coalfire, for example, walking the client carefully, step by step, through what's going to happen and what the risks are when they happen. And so I'm sort of echoing some of the points here of this last person who left comments here. So it was really Coalfire's responsibility. One little interesting fact in this case is that these Coalfire employees broke into another county courthouse the night before. So the night before, they were in Des Moines. And Des Moines is the capital, but it is also the county seat of Polk County. So these employees, the penetration testers, they get into the state court building, and then they go over to the county courthouse there in Polk County, and they got in. And the state court administrators later indicated that they did not know until long after this thing had broken that the Coalfire employees actually had gotten into the Polk County courthouse. And so that's a example of poor communication, where Coalfire is not telling its client, I'm getting into your building, but I'm also going over here and I'm getting into this county building. You should just know what I'm doing. Whereas better communication would be keeping the client up to date on step by step what is going on. A question that I had in my mind as I was thinking about good judgment and whether the employees were getting the proper supervision or they were making bad decisions was, why were they doing this at midnight? Were they under time pressure to get this thing done? Or was midnight standard procedure at Coalfire? None of that was known to me or clear to me. And the answers to questions like this could have been relevant to the prosecutor's decision whether to press the case or drop the case. So these are examples of facts that I just don't know. And another fact was, did Coalfire management fully know what its employees were doing? Did Coalfire management know, for example, that they were breaking in to the courthouse at midnight, or were they sort of freelancing out there on their own? I don't know the answers to that. Another generic lesson from this case is that the documents use different words in different ways, at different times. And in particular, when the sheriff shows up, the employees from Coalfire said, here, I have a get out of jail free card. So it's a formal document. It's very well known in the cybersecurity, especially testing world. It says here, these employees work for Coalfire. They're authorized to do this kind of work. Here's the telephone numbers for the client who have authorized them to do this work. And unfortunately, this get out of jail free card was not well written. For example, it spoke of social engineering. It says these guys are authorized to do social engineering. Now, the sheriff looks at this at midnight and he thinks these guys are not social engineering. They're not socializing with anybody. What they did is they picked the locks. And the get out of jail free card didn't say anything about picking locks. It says social engineering, which means something like tailgating behind somebody as they go through a secure door, or impersonating somebody to try to get into a door. In addition, there were 3 names and telephone numbers on this get out of jail free card, and these were the employees of the state court administration. So the deputies start calling these people at 1 o'clock in the morning, and 2 of them pick up their phone and they give inconsistent messages. One employee from state court administration says, yes, the Coalfire employees are supposed to do that. But the second employee says, I'm not sure they're supposed to be doing this at midnight. Well, man, if you're trying to get out of jail free, that's not what you want your client to say at 1 o'clock in the morning. Say, I'm not sure they're supposed to be there at this time. In other words, there was misunderstanding, miscommunication, poor documentation among Coalfire and the client. Then the deputies call the person with the 3rd telephone number, and it's the wrong number. So they call at midnight or 1 o'clock in the morning, and the number doesn't work. Well, that's not going to help you get out of jail free. And so the sheriff is smelling a fish here at 1 o'clock in the morning as he's looking at Coalfire's documentation. And so then the get out of jail free card said that the Coalfire employees would not engage in alarm subversion. And that was a question of fact where there was a disagreement. And I don't know what the facts were, but the prosecutor and the sheriff were saying that an alarm had been subverted. And the lawyer who worked for the Coalfire employees said, no, an alarm was not subverted. So I don't know what the facts were, but that was part of the controversy here. In addition, the get out of jail free card said that the Coalfire employees would not, quote, force open doors. Okay, they won't force open doors, but what about lock picking? And it didn't say. So this get out of jail free card says that they're there to do social engineering, but what they do is they pick the doors, and the sheriff looks at this and he says, look, you guys pick the doors, and it says you're not supposed to force open doors. Another example of poor documentation is that one of the terms of engagement spoke of this happening on mountain time. Well, Coalfire is based in Colorado, and that's why I think that their boilerplate documentation speaks of mountain time, but Iowa is Central Time. So it just shows sloppy documentation. And the terms of engagement spoke of doing things in the evening. Question, is midnight the evening? Well, I don't think of midnight as being the evening. I think midnight is nighttime. And okay, so then there was this confusion about what was actually authorized. Okay, so then somebody says, how was the door secured? Purely by physical keys? Question mark. Okay, so that's a controversial topic itself. So I heard, but not sure that I had this perfectly nailed down. I heard someone say, and actually I think it was, okay, later the president of Coalfire writes this blazing blog article and defending his people. And he says, my people walked up to the front door of that courthouse and the door was unlocked and ajar. You could just open it up. And then what they did is they pushed it back into place and it locked. And then they went around and they picked the various locks. That's all I know. That's all I heard. Now, this is just what the president of Coalfire said on his blog, and he was, getting very politically worked up on his blog, criticizing the county for not letting his people go and not dropping the charges. So that's all I know about okay, very interesting topic. Glad. Okay, so it looks like somebody is leaving, and they said, "Excellent job, Ben." But I'm not finished quite yet, because I've got 6 minutes left. So on the topic of boilerplate documents, they were using a master agreement from an earlier 2015 engagement that Coalfire had with that Iowa State Court administration. And you read the master agreement, and it didn't say anything about lock picking. And so as you really tried to understand what was authorized, there was a good deal of confusion in the mind of the law firm that carefully read the documentation and tried to determine whether what the employees did was authorized or not authorized. Another point that the law firm made in its report is that the documents jumbled together a lot of different kinds of terminology: penetration testing, red teaming, and so on. And the law firm said, you're mixing these things up, and penetration testing is not the same thing as red teaming, but you've got basically a boilerplate, a document that was kind of cobbled together over the years and didn't reflect very careful legal draftsmanship. One point I've got to make is that it's easy for a lawyer like me or for that law firm to nitpick somebody else's documents and say, oh, well, you should have hired me. And if you've hired me and spent thousands and thousands of dollars, then I've given you a nice, clean document. But of course, it's expensive to have a lawyer involved on every engagement and clean things up. So as we're getting here toward the end of the presentation, when I participated in this conference in Adel, Iowa in October, it may have been November, I can't remember, October, November, it was back in the fall. A number of other people gave presentations. Most of them were giving the presentation virtually. And a company named Trusted Sec was one of the presenters, and David Kennedy, I think, is the CEO who gave that presentation. He said that his company had paid a lot of attention to this particular incident and decided that it was going to update its own form for penetration testing. And so he said, we have published our form for penetration testing work out on GitHub, and I've given you the URL where you can go take a look at their form. And they've added a clause to their form where the client agrees that the client will pay the penetration testing company $25,000 for each penetration tester who is criminally charged. And further, the client would agree to pay all legal defense expenses. So I think, wow, that's interesting, getting the client to agree that if your people are arrested, then I'm going to pay $25,000 and I'm going to pay all of the legal defense expenses. I have no idea whether the state court administration paid the legal expenses to defend the Coalfire employees. I could imagine Coalfire pressing that claim, but I don't know how the state would have responded to that. And if I were the client, I would look at some language like this with a very skeptical eye, because I don't want to pay $25,000 for penetration testers who are criminally charged if they exceeded their scope of work or did something else that was not permitted. And that then becomes a really dicey thing to try to fully define exactly what is the scope of work, especially when you're dealing with facilities that are strung out in lots of different places, like different counties around Iowa. And if you're just talking about a penetration tester trying to get into a single building that's owned by the client, that's one thing. But when you're talking about penetration testers getting into disparate buildings, physically separated out in counties, and in county courthouses and so on, trying to define exactly what they can do and what they can't do can be a lot of work, and it can require quite a bit of time to write the documentation. So to kind of summarize, my bigger lesson here is that these problems emerge in numerous different aspects of cybersecurity work, and we as professionals are wise to exercise intellectual rigor in thinking through what are the risks and what do the documents say, and have we properly communicated with our client what needs to be done and what we are doing. So I have bottom of the hour, so we've pretty much covered this, and in fact I need to shut down myself, and I've answered all the questions that are here now. So at this point I am going to sign off and say goodnight, and I know that SANS has other @Mike talks scheduled, so I encourage you to keep up with SANS, and you can come participate in future talks. Somebody says thanks, great job, happy beer time. Exactly, I'm going to get a beer. Good night.